Welcome. I'll just wait a few more moments for everyone to get connected here. All right, I'll go ahead and look to our court reporter. Are you ready for us to go on the record this morning?
I need just one more moment, please, while I
Sure.
see who all is here. Thank you.
No problem.
And I see Ben King. Can you tell me who you're with?
Yes, TNM King Farms LLC.
Okay, so did you say TNM?
T anchor Sam M King Farms LLC.
Thank you so much.
Thank you.
Okay, I'm ready to go when you are.
Thank you. All right, I'll go ahead and start with our introductions. Good morning. It is the morning of March 11th, 2025. I'm Nicole Kinsey, presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board. This is the hearing on the pending petition for assignment of state filed application 25517 and accompanying water right application 25517X01 and the pending requests for release from priority of state filed applications 25513, 25514, the unassigned portion of 25517, 22235, 23780, and 23781 in favor of water right application 25517X01 of Sites Project Authority. Today we continue the rebuttal portion of this hearing. The hearing is being conducted by Zoom teleconference and is being broadcast live on the AHO YouTube channel. As always, the audio and video are being recorded. We will post files of that recording, and the YouTube recording will be available on the AHO YouTube webpage. If you're experiencing technical difficulties, please send us an email and the AHO team will let me know. Once again, Ms. Mullen will be handling slides for us today and screen sharing. So if you're a witness, you may simply ask Ms. Mullen to advance to the next slide. And those who are cross-examining may ask Ms. Mullen to please bring up a particular exhibit. We will take breaks today. I did want to note today, and I apologize in advance, I do need to take a break from 11 to 11:30. I realize we talked yesterday about our schedule for Ms. Moreno. Um, I know we had hopefully would have Ms. Moreno completed and off the witness stand before lunch. I am willing, we can talk about how things play out as we go forward, but I'm willing to push into the noon hour if we need to get because of this break to get Ms. Moreno completed and excused for the day. So I will try to work with all of you, but once again, we will be taking a break from 11 to 11:30. I don't anticipate we'll go to 5 p.m. today, but we will, of course, make a hard stop at 5 p.m. If we get to that point. I will carry over appearances as usual. My understanding for where we are this morning is that we will hear from Mr. King first, and then we will move to Ms. Moreno, and then after that, which I anticipate will be after lunch, but we'll see how things play out. We have a number of procedural items that we should talk about. One is moving rebuttal evidence into the evidentiary record, noting any evidentiary objections to any of those items, those exhibits. We would like to get an indication and have a discussion with the parties about what the need for any additional hearing days. And I think I will share my perspective on that as well. And then we should talk about deadlines, both for evidentiary objections, responses to evidentiary objections, and then potentially closing briefs. So that is what I see for the afternoon, and there may be some other next steps type issues, smaller items as well, of course. I will look to you to remind me what we're forgetting. But with that orientation, is there anything else we should talk about before we turn to Mr. King? All right, then with that, Mr. King, I know I have administered the oath to you previously. Do you recall taking the oath in this proceeding during the case in chief portion of the hearing?
Yes, I do.
And you understand that you are testifying today under oath and under penalty of perjury?
Yes, I do.
Thank you. Then with that, Mr. King, if you would please go ahead and summarize your written rebuttal testimony.
Okay,
Excuse
I
me,
have,
Hearing Officer Kenzie, if I could, for a moment, since this is a little bit of an unusual circumstance where the witness isn't represented and will be summarizing his rebuttal testimony, I don't want to interrupt the flow while Mr. King is doing that, but I think it's important to lodge some objections for the record before he starts to summarize what we view as objectionable content.
Sure, and then we will forego doing this later, so at least we're moving forward. Okay.
Yeah,
please.
that's fine. I appreciate that. Yeah, I would say to the extent that Mr. King is intending to submit any of his testimony as an expert witness, we would object on the ground that it's not admissible expert testimony. Also, there are a number of sections that is improper rebuttal testimony, pages 1 through page, and I'm referring to the corrected version that the AHO office posted yesterday. Pages 1.
And just for a moment, for the record, Mr. Hitchings, we're referring to King 84, which I understand is Mr. King's written rebuttal testimony, and then you are referring to the corrected version of King 84, which the AHO formatted and posted to the FTP site.
That's correct. Thank you. And so of King 84, we're objecting to pages 1 through page 3, line 11, on the basis it doesn't respond to case in chief testimony, which is not in compliance with the hearing notice. Same thing with page 10, line 34 through the end, does not respond, specifically specifying any previously submitted testimony. It also includes essentially policy and legal conclusions that are not appropriate for this part of the proceeding. With regard to any reference in Mr. King's summary to King 80 or King 82, there hasn't been any witness with relevant experience to lay the foundation for those exhibits. With regard to exhibit King 85, despite the title of the file, the document does not reflect ownership, sale, or the terms of that sale. For instance, whether T&M King Farms retained certain parcels, and it cannot be submitted as evidence for those facts. As to King 88, pages 2 and 3 of the PDF don't have a title page or other identifying information regarding the source of the document to lay a foundation, and King 89 is illegible. Thank you for allowing us to state those for the record, and appreciate, and we will just carry those over for what we would otherwise state verbally today.
Thank you. With that, back to you, Mr. King.
So should I respond to that, or we respond to that in writing later? How do you want to?
So I think that's a good question. In the past, I think for case in chief, you would prefer to respond orally. I want to retain that option. If you prefer to respond orally rather than in writing, that is fine, but let's do it later today so I have a chance to revisit these exhibits. I think that will help orient me rather than doing it right now. Let's go ahead and go through your testimony, and then we can, please don't hesitate to remind me to return to this. And once again, you have the option, Mr. King, if you would like to respond orally, or if you would like to respond later in writing, either would be fine with me.
Thanks. So I have 4 corrections, and I apologize. And so I am actually going off my Word document, which I'm assuming is going to be pretty close to what was revised by by your office, Ms. Kinsey. I didn't have a chance to see that yesterday afternoon. So first correction is on page 1, line 14. I referred to Exhibit 57, which should be Exhibit 3. And then second correction is on page 1, line 33. I referred to King 11, which should be King Exhibit 4. And the third is, there's two corrections on page 5 also. The third is page 5, line 15. And I refer to King Exhibit 35, and I should note that it's page 9 of King 35. And last correction is on King 5, line 25. I want to replace the word below with the word between. So it reads, no plan for the long-term sustainability of the portion of the Colusa Basin drain between the Davis Weir and not below the Davis Weir.
Thank you, Mr. King. And if you would please follow up with a corrected version of the document, that would be helpful.
I will. Thank you. Thank you for the opportunity. So thank you for the opportunity to be part of this hearings, and I'm submitting my rebuttal testimony. So I will do my best to summarize. But as I've mentioned before, the T&M King Farms now owns 265 acres, 235 of which 35.414 acres is now with the NRCS Wetlands Reserve Plan. And that is, that document is on King 23. And if Ms. Mullen actually could bring up a King Exhibit 3, I appreciate that. And if you just could scroll down and I think I've laid foundation before this, but this is the Colusa County history, the publication date of 1880. If you scroll down the next page, it's by Will S. Green, and there's a picture of Will S. Green. So if you could go down a couple more pages and find the document, page 57. Page 57 of this publication. Right there. So this is, and if you could, I don't know if you can magnify that any and go up for you see the title of this document. This is a skeleton map showing the natural overflow of floodwaters of the Sacramento River and the mountain streams emptying into the trough. And if you could just maybe, it's a large rectangle, if you could frame that, Ms. Mullen.
What do you ask? I'm sorry, Mr. King. What are you asking Ms. Mullen to do?
Just kind of frame that rectangle.
I see.
Yeah, there you go.
Great.
And you can see there on that, there is an upper basin towards the lower half of it. And then there is a denotation of Sycamore Slough, which is conjoined with the Sacramento River, and then the lower basin. And to the right, if you look at the text, and that the title is Reclamation of Colusa County, there's in the yellow highlighted, it says, as a slough forms for itself a ridge, it cuts the basin in two, leaving a narrow passage to the west for the overflow from above to pass down the valley. This is what I cited, but also this is where the historical King property, my great grandfather was settled on. and it was Putland land, but that's the place. And so that is the topographical and geographical context of our water rights prior to reclamation. And then, Ms. Mullen,
And
could
Mr.
you?
King, I know this is unconventional, but I have a question about this map, which you may not know the answer to, but I'm going to ask anyway.
Yeah.
So the arrows, is it your understanding, based on reading, as I understand you've read this text, that the
Yeah.
arrows show flow of the water, so that these arrows that are coming off of the Sacramento is actually flow of water away
Yes.
from the Sacramento River to, I guess would be low-lying lands, something to that
Correct.
effect? Okay.
Correct. Yeah, and so you can see up to the upper first one third of it. You can see Willow Creek. They've denoted Willow Creek um, coming down, and then the Sycamore Slough actually was the overflow into primarily the lower basin, which is now mostly RD 108. And you can see the direction of the water coming from the river down as a grade of the valley, but also each one of those arrows coming in represents water from the ephemeral streams. And right north to us is Salt Creek and then Cortina Creek. And so you have, I think, 17 different ephemeral streams. And so the arrow below Willow Creek would be like Stone Corral and Funk's Creek.
Thank you. Appreciate
Thank
that.
you. So if we could bring up Exhibit 11, Ms. Mullen. So this is, we have several of these deeds, but this is one deed. And the grantee is Thomas C. King, which is my great-grandfather. And the reference is some property in Section 30. There's also other deeds that refer to other sections. But if you scroll down, Ms. Mullen, you can see at the bottom in the testimony, it says, whereas Ulysses S. Grant, President of the United States, has caused his letters to make a patent and sell of the General Land Office hereon, and it's the dated 15th of May, 1869, and it's signed by U.S. Grant, and then undersigned by one of the secretaries, and then the recorder of General Land Office. But this is the legal ownership from the land that my great grandfather settled. That was Putnam land prior to that period. So, Ms. Mullen, can we now go to Exhibit 4? And if we can maybe make that as large as you can. And this, so if we can focus on the bottom part for the date, the very bottom writing, if you can make that a little bit bigger. Scroll down a little bit. So this is an original map filed in the office, the Surveyor General's office in San Francisco, California, November 19th, 1868. Actually, so this is a whole map, and this is Township 14 North, Range 1 West, which our property is located in. And you can see, if we maybe scroll up a little bit, Miss Mullen, for we kind of frame the bottom third of that. Yeah, go down a little bit more. Yeah, thank you. So you can see Sycamore Slough denoted in here, which runs north to south. And you can see, let's see, if you go upper left-hand corner, it says the word swamp. And then you go a little bit farther down on a diagonally from left to right, swamp and overflowed land. And then below that, unfit for cultivation. And then to the immediate left, where there's a kind of um, I don't know, a border, the kind of a darker border that goes um, down from north to south. That wording actually goes from bottom to up. It says swamp and overflowed land. And our property is right at that point where that swamp and overflow. So you can see the same thing as it's the same topographical and geomorphical setting as the Willis Green map, where you can see it's located directly west of Sycamore Slope. So thank you, Ms. Mullen. So that's the basis of our riparian rights um, assertion. But the first appropriative rights, so we have riparian rights, we assert that we have riparian rights, and then our first appropriative right was actually decided by decision 680, State Water Resources Board decision 683 on November 27th, 1950, where Glen Cluse Irrigation Districts and Maxwell Irrigation District and other irrigation districts protested application 12459 and several other water rights. In that decision, State Water Resources Control Board, decision 683, actually overruled the protestants, and the rationale was that the water in the Clusa Basin drain at that point, which was historical Clusa Trough, was essentially natural. And I cite on page 39 of decision 683, in my submission, there's a paragraph in the conclusion, the first sentence of conclusion, and just I'll mention a couple things. One, in it says that the waters of any origin drainage area, which includes the lands of the applicants and the protestants in the matter at issue, is essentially natural. Excess waters naturally find their way and have found their way from time immemorial into the so-called trough of the Clusa Basin. And then the last sentence says, from a standpoint of applications to appropriate water, the channels composing systems are considered in legal effect as natural channels. So again, this is our appropriate right, but we have appropriation of, the appropriate right is based off of appropriating from a natural channel. Again, there was another State Water Resources Control Board decision, which referred to the rights of the diverters on the Clusa Basin drain. And this is, it's in Exhibit King 77, it's State Water Resource Control Board decision 785, which was decided 5 years later on February 15, 1955, where George Zumwalt of the Glen Cluse Irrigation District protests Lewis Sutton, I believe of the Maxwell Irrigation District, and they did a field investigation in 1953, and the field investigation findings were set on page 4 of that decision. And one of the findings on page 4 says that during the major portions of the irrigation system, all or most of the flow and drain consists of waste and return waters from irrigation operations within the drainage area. So during the irrigation system, natural flow is present in the spring and during storm periods. And it is possible that some is present at all times. The chief contributor in this respect is Willow Creek. So again, it talks about the mixing of return water, but also natural water being possibly present at all times. And denotes Willow Creek as being a major contributor. State Water Resource Control Board decision 747, which was decided in 1952, after application 12459 was affirmed, by the State Water Resources Control Board in 1950, my grandmother, Luda King, and Mr. Orville Cole protested an application by Maxwell Irrigation District. And we actually, and she, on behalf of asserting her rights under application 12459, asserted riparian rights on page 2 of that decision. I'd like to, Miss Mullen, could you bring up page exhibit 76? Miss Mullen, it's a photo. So this is a photo that we took on November 26th of 2024. Go up, I think, the previous page, the previous photo. Yeah, and so this is the northern boundary of our property, and we had a storm event in Colusa in Sacramento Valley in November, and you can just see the flooding. This is natural flooding. So this is a natural state of riparian flooding. So even today, when it's not being dammed by diverters upstream, the water flows in a riparian nature on our property. Finally, thank you, Mr. Mullen. Finally, I mentioned that we actually, T&M King Farms paid for the record survey, which is in power of public records in Colusa County. We of the 265 acres, we retain approximately 15 acres of those are actually within the riparian levee and the channel of the Colusa Basin drains, either the complete channel or part of it, which is excluded from the wetlands because the NRCS doesn't take an easement on the natural levee or the channel of the riparian habitat. And we have 15 acres outside of that that's not subject to it. So 235 within the Wetlands Reserve Program and 15 within the channel of the riparian habitat itself. All right, so
Excuse me.
Yes.
Hearing Officer Kenzie.
Yes.
I think we've been going about 15 minutes now, and Mr. King is basically marching through each paragraph of his written testimony, not particularly summarizing it. And so I just wanted to note, and I don't know where he is with his allocated time, but I just wanted to note that it seems like we're kind of moving quite slowly beyond just summarizing the rebuttal testimony.
Thank you, Mr. Hitchings. And I was well aware of this, although I do want to spend, because the water rights here, I think, are the essential aspect here. So I was allowing Mr. King some leeway to march us through that. I think I share your concern. I look at the volume we have left, and on the clock, I don't have this precise number in front of me, but it was in the range of 20-something minutes total, Mr. King. So I think it is appropriate as we go forward to make sure we move through this in a summary fashion, please.
Okay. Thank you. Well, that's the end of the first part of the water rights. So my other rebuttal testimony is that the Sites Authority did not consider the appropriative, the prior appropriative or riparian rights of Stone Corral and Funk's Creek flows downstream of the confluence of Stone Corral and the Colusa Basin drain, and therefore meet the requirements of the two components of the water availability analysis. And so I will just mention that I before I knew there was actually transcripts based off our previous conversation that I thought I had to go to the written testimony. I cited went back to the recording and have what I believe to be true and correct quotations of Mr. Walker, Mr. Brazzoni, and one of your questions actually confirming that they did not consider the water rights below Funk's Creek and Stone Corral Creek, so the confluence, with occlusive basin drain. They do not consider water rights or whether or not there be water available for downstream programs. So I will just, that's the summary of that. I have specific quotations. I mentioned those in both my discussion on page 3, at the bottom of page 3, and the top of page 4. So you can see that I would mention that one of the questions was regarding water availability. You asked this question at Ms. Kinsey. Did either of your water availability analysis consider in-stream flow requirements to the extent that there are any in the occlusive basin drain? And Ms. Bozzoni answered, I'm not aware of any in-stream flow requirements within the occlusive basin drain, and none were included.
Mr. King, I've read the testimony,
Okay.
and I will read it again. I assure you. But
Okay,
I think
great.
if you can move through this in summary form, that would be
So
great.
my last point is that I've mentioned this before, but the final State Water Resource Control Board decision, which I think is applicable, is State Water Resources Control Decision 1590, which was decided in February 17th, 1983. And it talks about the requirement to protect in-stream beneficial uses below the Davis Square Dam. So the next section that I'd like to summarize is that I do not believe that the current operations plan of the site's reservoir is substantially in accord with the 1977 application that is being considered to be transferred. And the reason I don't believe it's in accord is because there was never anticipated that water from site's reservoir would not travel down the full length of the occlusive basin drain. It was every application, every state filed application, water right asserted, and even the submission to the California Water Commission in 2017 assumed and included provisions that all the water coming out of the reservoir would be traveling down, would either be used on the TC Canal or travel down the full length of the occlusive basin drain, which is consistent with the natural flow down the occlusive trough. And I'd like to point out that in Sites Exhibit 1, Section 22, there's reference to a May 23rd, 2018 report to the California Water Commission saying that there'd be 35,000 acre feet of additional level 4 water for the Sacramento National Wildlife Complex via the flows of occlusive basin drain. There was no update to that, I know, but the Sacramento National Wildlife Refuge, consists of the Sacramento Refuge and the Delavan Refuge and the Coosa Refuge, all on the Coosa Trough. And so there's been no extra reconciliation of what that statement is and how the site's water is going to be made available for the Sacramento Valley National Wildlife Refuge complex. I also note that as I mentioned before, is that there is an issue of water quality, which will be alleviated if you have more flows down the Coosa Trough. And I refer again to the water management plan for the Sacramento National Wildlife Complex, and I refer to King Exhibit 35, page 9, where we talk about the contamination of groundwater by mercury and hexavalent form of chromium. And I referenced that in King Exhibit 69, I referenced the 3 dams, one on Willow Creek and one on Maxwell Road by Maxwell Irrigation District, and the one by Davis Weir, the Bladder Dam by Glen Close Irrigation District, which
Mr. King,
yes.
You really need to summarize. I mean, you're
Okay.
walking us right through your testimony, and I have read it.
All right. So,
So I suggest maybe 1 or 2 sentences per page, and then we can get through this.
okay, I have to pick my things in. I do not believe that the operation, which is different, substantial, that one material difference between the prior applications and the submission of the operations plan that would be implied or expressly stated in the 2017 submission to the California Water Commission is that there's no plan, absolutely no plan for the long-term sustainability of the area of the Coosa Basin drain between Davis Ware and Balsam Dam. Page 6 of my testimony, I denote the testimony of Mr. Robinette at one of the field sites where again he confirmed that there was no plan for maintaining water levels between the Davis Ware Dam and the Balsam Dam. I'd like to bring up King Exhibit 79, if I would, if I could. These photos. There you go. So one of the questions to Mr. Robinette at the field site at the Balsam when we stopped at Balsam Dam was whether or not he knew what the difference in elevation was between the area of the Coosa Basin drain north of Balsam Dam and south of Balsam Dam. Here is a photo from October 22nd, 2024, when flows were cut off at the Davis Ware Bladder Dam. And I actually took photos and stood in the drain because there was no water flowing. And you can see the elevation differential between the bottom of the Balsam Ware dam structure and the water in the Coosa Basin drain below the Balsam Dam. And that's about 2 feet. And if you could just scroll a little bit more, there's four photos. There's another picture of that elevation differential. And then a little bit farther up, and there's another elevation differential, and one more. And there's me standing in the Coosa Basin drain, and there's total about 6 feet between the top of the boards and where the water level is. I want to mention that this is another material difference in the 2000 in the water in what was assumed in the state of flows with the original application and what is now operation plans of sites of the site submission is that there's no provision to maintain water levels for groundwater recharge for the domestic wells in College City, managing subsidence in the area, or the groundwater dependent ecosystems. And I refer to the testimony of Clark Ornbaum referring to about how the interconnectivity of groundwater levels, the water levels for the domestic wells in College City, and the importance of the water for the ecosystems on Dry Slough and Sycamore Slough.
Excuse me, hearing officer Kenzie. We're now 10 more minutes into it, and we are still at page 6 of Mr. King's testimony. And I just believe that we are not marching through a efficient summary of his testimony.
That's right. Thank you, Mr. Hitchings. I think we have now reached the expiration of your time limit, Mr. King, but I'm going to what I intended to do was to give you a 5-minute warning.
Okay, so I have 5 minutes left?
5 minutes. So it's
Okay.
9:42, we'll go to 9:47.
Okay. So, on rest of page 7, I basically refer to the 25 miles of flat hydrology, of the Colusa Basin drain. And that should be considered as when we look at the water coming from the proposed pipeline at Bird Creek. On page 8, I refer to a study from Stanford talking about the presence of chromium and the redox, desorpted of the hexavalent form of chromium, and referring to NIH study regarding how that could be toxic for certain species of freshwater fish, and also the ubiquitous nature of that chromium and the potential for the hazard of both human health and aquatic health from the redox desorption of the hexavalent form of chromium from chromium because of the presence of manganese and chromium in the right pH environment. So that's page 8. Page 9, I talk about that area around the Colusa Basin drain, which is adjacent to RD 108, basically as 25-mile sump. And you can, it's impaired water body. We have dissolved oxygen issues. We have mercury issues. We have excess salinity issues in the Colusa Basin drain, and partly because there's no gradient there. Page 10, I refer to one of the better recent studies by people at UC Davis. It's the my King Exhibit 81, the Colusa Basin drain area fluvial sediments. And it has certain recommendations about how you actually can manage water flows in the Colusa Basin drain. And that's by Andrew Gray and Gregory Pasternak in 2016. And then finally, I make the point that the way the MOU is structured between Colusa County and the Sites Authority is that if it actually did come to pass, it would be unconstitutional taking based off the recent Supreme Court decision of De Valera versus Texas, which was cited in 2024. But more importantly, probably is that there isn't any area ordinance protections in the MOU, because the way the document runs is that if Colusa County loses any of its rights and can't afford to pay the fees, which they've already paid $7 million for, and with a $3 million current operating estimate, is that those flows would go to the other storage partners, like Metropolitan Water District, like City of Roseville, Placer County, outside of the area. And if there was any benefit to the other storage partners, which are currently in Colusa County, there's no guarantee that they will keep that right or actually use it. They have to actually pay for all the money they spent and will be potentially likely to sell that right. So the whole idea that somehow there's protections for area ordinance by the MOU is really dependent on conditions and mostly improbable. So do I have a minute left?
You did. Excellent.
Okay, well,
Thank you.
thank you very much for the time. And I think I'm not exactly sure what the objections were. So maybe I'll have a chance to think about what the objections are, and then we can talk about those later.
That sounds good, Mr. King. Yes, I'm thinking we'll probably get to this after lunch, the objection portion. And thank you, Mr. King. I have a couple questions for you that I think it makes sense for me to ask now, and then the parties will have a chance to, if they want to cross-examine about any of your responses. And I'm focused on really the first part of your summary and the water rights associated or held by T&M King Farms. And I believe it's, from my recollection, you had mentioned, or it was part of your testimony in the first part of this proceeding, that you had relatively recently sold some of the property. Are any of the water rights that you referenced in this testimony, were they transferred with the sale of that property?
One, so we have four appropriate right, in addition to our riparian rights asserted, we have four appropriate rights. One is 12459, which is a priority date, 1948. And then the other three are 1980 and 1983 appropriate rights, one of which for 825 acre feet, I believe. I forget I mentioned it, but what's permitted is, I think it's through 19333. That's being transferred with approximately 100 acres that was sold to a farming operation that's going to continue to use that water right for its farming. So that will be outside of our use for just wetlands and riparian habitat. So that's detailed in the water right submission that the information I submitted to you. But
Thank you.
so the three appropriate rights now are beginning. So we're talking to the California Waterfowl Association right now and working on a project, and so we'll be on a project for a year or two, and we'll convert we'll modify our diversions to have more free flow for we can flood during winter and spring for waterfowl habitat primarily. And also groundwater recharge. So we're trying to make it a multi-benefit project.
Thank you, Mr. King. And then have you or your predecessors in interest to the property, to your knowledge, diverted under your riparian water rights?
Yeah, so we've diverted in we personally have diverted in the wintertime outside our appropriate water rights, one of which starts in March, and three of which the applications, the 1980 and 1982 applications have a March beginning of March diversion period, and the ends in November 1, and then the 1948 one has a May 15th. So we actually have diverted before March we've used water and flooding for pre-irrigation on the almond acreage that was riparian at that acre time, and then also for frost protection. So we consider that diversion of the riparian, using our wide riparian rights, since the diversion is before our diversion periods under the appropriate applications.
Understood. Thank you. And then do you file, and you may have submitted these, I haven't looked through all of the documents yet, but do you file statements of diversion and use for those riparian rights so that I could, where would I go to see how much?
Yeah, so you can go, you can go to our annual, the annual license reports, and we refer to that in the last couple of years. We weren't focused on that until recently, but yes, and actually that's when we did it. So especially for the frost, and then we did have. Well, I also mentioned that we did have 40 acres that we actually used for, we worked with the NRCS for duck water. And so we did that too, I think a year and a half ago. But primarily it's been for frost protection. And then when there's water in the drain, we've been doing pre-irrigation and then kind of use that for groundwater recharge. So, but we do mention our riparian rights in the most recent license report. So.
But you don't have a separate,
No.
You have not filed a separate statement.
No,
So
we have not,
number.
Frankly, I wasn't aware that people had done that, and now I'm aware that people actually have filed riparian rights. So we're asserting that since they can't be extinguished, that we're asserting them, especially now, because the sole purpose of 245 of the 260 acres is for groundwater recharge and riparian habitat, which is dependent on our riparian rights, which overlaps with the diversion period out of the site's authority and their assertion of their water right to potentially Stone Crown and Funks Creek.
And do you claim that all of I guess I'm trying to understand the overlap between the appropriative water rights and the riparian claim.
Yeah.
All of the land where all of the place of use for the appropriative water rights, is that also you would claim a riparian
Yeah,
claim
so
to land as well?
of the 1948 right is not subject to term 91. So we're asserting that, and we're asserting that there's natural flow year round in the drain for that 1948. The other two of the permits that the 1980 and 1982, we're asserting both appropriative and riparian for that place of use. Um, so it is all riparian, and it's all been continuous land ownership since since we were granted the legal right of the Putman land in 1869 or around that period. We've been farming it since 1860. So we're going to assert, the riparian right. We're going to assert appropriative rights. Well, I won't get into the Federal Reserve rights from potentially with the USDA, but it's important riparian habitat, and we're going to assert whatever rights it is to protect both in-stream uses and our use as wetlands going forward.
Understood. Thank you, Mr. King, and thank you for answering my questions.
Thank you very much for the opportunity.
I will look to Mr. Hitchings. Do you have questions for Mr. King?
Yes, thank you. Good morning, Mr. King.
Mr. Hitchens.
So I just wanted to start out, this is tied back to some of the objections we noted earlier. With regard to pages 1 through page 3, line 11. Oh, and Mr. King, I'm referring to the corrected King 84 exhibit. Since that was sent yesterday by the AHO, I just emailed it to you so that you have it, but we can pull it up as well. Because it sounded like you had not had a chance to pull that off of the AHO FTP site.
No, I did not.
Okay, well, maybe we should well, I'll just ask you this generally. Pages 1 through page 3, line 11 of the corrected testimony, you don't specify any previously submitted testimony by sites or anyone else that's being rebutted by the content in that section of your written testimony, correct?
Well, yes, I think I am. I think Miss Forsythe, in like the second day of hearing, said that she wasn't aware of any beneficial in-stream rights or any riparian habitat below the Davis Weir Dam.
But you didn't specify Miss Forsythe's testimony in that section of your written rebuttal testimony, correct?
That is correct.
And with regard to pages 10, line 34 to the end, same question. You don't specify any previously submitted testimony that is being rebutted by the content in that section of your testimony, correct? And that's the portion of your testimony that starts with the heading, the MOU between Sites Project Authority and County of Colusa through the end.
Yes. Well, Mr. One of the Friends of the River, one of the Friends of the River parties talked about the area of ordinance protections and MOU. And we had a lot of discussion regarding the testimony regarding whether or not what happens to the county's rights in the memorandum understanding. So there was substantial discussion about, what would happen if the county didn't continue to own that, and whether or not that water would go out of the basin and not actually affect or uphold the area origin protections that are necessary for the application. So
But
that was
you didn't specify the Friends of the River testimony or any other specific testimony that you're rebutting in that portion of your written testimony, correct?
correct.
And just to be clear, you're claiming that T&M King Farms holds riparian rights on the Colusa Basin drain that may be impacted by the site's project. Is that correct?
Absolutely, yes.
And I wasn't quite certain of the answer to this, but have you or T&M King Farms ever submitted a statement of diversion and use to the State Water Board that provides documentation of your claimed riparian right?
Well, we've asserted it in our one of our license submission, and reports, but we haven't actually filed for riparian rights. We didn't, it's not my understanding we don't need to. They can't be extinguished. But we've had discussions about our riparian rights.
Are you aware that there's mandatory requirements under the California Water Code for riparian right holders to report their water diversions and use to the State Board on an annual basis?
No, I wasn't aware of that.
So you have not submitted supplemental statements of diversion and use for your claimed riparian rights to the board on an annual basis. Is that correct?
We've included that our assertion of riparian rights in the recent filings, referring back to our deed in 1969 as part of the submission that we had for the four appropriate rights.
But you've just simply included that content in your licensee annual reports for your appropriative rights. There's nothing that specifically was filed to assert your separate riparian rights. Is that correct?
No, not as a state, but once we actually get our wetlands up, we will do what we need to do to protect our rights.
Do you have an understanding that a riparian right holder only has the right to divert natural flows from the appurtenant riparian watercourse?
Yes, and that's why I referred to the State Water Resource Control Board president saying that the water in the drain is natural.
And do you agree that natural flows refers to naturally occurring patterns of water flow, which may vary in volume, timing, and flow rate throughout the year?
I'm referring to the conclusion of the State Water Resource Control Board, which said that the intermixing of water because of the changes that are made to the historical Colusa Trough, that the water actually is legally natural.
So your claimed points of diversion for your claimed riparian rights, they're on the Colusa Basin drain, correct?
Correct.
And not all of the natural flow in the Colusa Basin drain is from Funks and Stone Corral creeks, correct?
Correct.
Do you agree that Funks and Stone Corral creeks generally add water to the Colusa Basin drain during times of high flow periods, like a storm event?
Yes, and other times outside storm events.
But the large majority of times when they would be adding water to the Colusa Basin drain, it would be during a high flow event like a storm event, correct?
I don't know if you can make a large. It's differentiated. It's there is always flow from the creeks for a large portion of the year. It's not necessarily a storm event, and also depends what dams there are upstream before you get the Colusa Basin drain. Specifically the Maxwell Irrigation Dam is before the Colusa Irrigation drain, so that doesn't add water at all if they've dammed that water.
Have you performed any quantitative analysis to determine if operations of the site's project would impact natural flows from Funks and Stone Corral creeks into the Colusa Basin drain?
No, I haven't.
Okay, Ms. Mullen, if we could actually pull up King 84, the corrected version. And if we could scroll to page 3, line 25. And here you state that no consideration was given to downstream appropriative and riparian rights, correct?
Yes.
And if we could bring up AHO 69, Ms. Mullen, please. Thank you. And you see that this is chapter 2 of the final EIR, and it contains a description of the project and project alternatives.
Yes.
And if we could scroll to page 86. And do you see, if we could scroll down to the heading that says diversion to sites reservoir from Funks and Stone Corral Creeks?
The diversion to sites reservoir. Yeah, that
Yeah,
paragraph.
and
Yeah.
correct. And then the last sentence of that section says water from Stone Corral Creeks would be diverted to storage in sites reservoir from September 1 to June 14, and senior downstream water rights on the creeks have been satisfied.
Yeah.
Do you see
Yes.
that?
Yes.
Mr. King, is it your understanding that your claimed riparian water rights would be senior to sites appropriated water rights, even with a 1977 priority for those sites rights?
Can you say that question again?
Is it your understanding that your claimed riparian rights would be senior to sites, the site's appropriative water right, with the requested 1977 priority date?
Yes.
And you are aware that in California's administration of water rights, riparian rights are generally senior to appropriative rights?
Yes.
Okay, if we could go back to King 84, Ms. Mullen. And beginning on page 4, line 37, you're asserting in this section of the testimony that the site's operations plan is not, quote, substantially in accord, end quote, with previous versions of the operations plan, correct?
Did you have a question? I'm sorry.
Yeah, I asked you that in that section, you're stating that the site's operation plan is not substantially in accord with previous versions of the operations plan. Is that correct?
Yes.
And then you reference Ms. Forsyth's case in chief testimony, cites 262C in this section at line 27, correct?
Correct. Yeah.
If we could bring up Ms. Forsyth's testimony, cites 262C. And if we could go to PDF page 16, which is the page that was cited, or slide 16. This is if you look at the first bullet point, the phrase quoted on the side, substantially in accord, that's what's you're quoting in your testimony, correct?
Correct. Yep.
Are you familiar with what is being quoted in this slide?
I don't understand your question.
Well, do you understand that she's quoting from Water Code section 10504?
No, there's no reference to that.
All right, if we could go to sites 71C, please. And if we could go to, and this is Ms. Forsyth's case in chief written testimony. If we could go to PDF pages 10 and 11, or start with 10. And scroll down to paragraph 40. And you see here, Ms. Forsyth states that the authority considered whether the project is substantially in accord with a state application that is part of a coordinated plan. And at the top of page 11, she cites to Water Code section 10504.
Yes.
So do you understand that that's what was being quoted and referred to on slide 16 of her summary presentation?
Yes. So yes, and now I know, but has both the plan and then water quality objectives. So that seems to be consistent with what's on page 16 of her presentation.
Okay, thank you. If we could actually go back to King 84. And on page 7, we could scroll there. Here, Mr. King, you assert that the site's project conflicts with water quality objectives, correct?
Correct.
But in this section, you're describing currently existing conditions of salinity, mercury, and dissolved oxygen in the Colusa Basin drain, correct?
Yes.
And then if we could go to PDF page 8. At line 13, you state that site's witness, Dr. Ann Huber, did not consider the impact of hexavalent chromium on humans or aquatic life, correct?
Yes.
Did you review the metal concentration data that's presented in Appendix 6E of the final EIR for the site's project, which is AHO 142?
I think I did. Yes.
Do you recall that that data included measurements of total chromium in the project area?
From the Sacramento River, but not from the Coast Range.
Well, weren't there other areas where they included measurements of total chromium just beyond the Sacramento River?
The reference, yes, but not anything from the Colusa Basin, from the Coast Range, from the natural occurring chromium in the Coast Range. She just referred to only Sacramento River sources of chromium.
Okay, thank you, Mr. King. That's all we have.
Could I ask which AHO did you when it came to Funk's there was part of the EIR Funk's Creeks. What was that 84 AHO 84? Is that what that was?
I'm sorry, I'm not remembering which question you're referring to.
It was the one regarding the senior rights, and you brought up I think the
Yes, it was AHO 69.
AHO 69. Okay, thank you.
Thank you, Mr. Hitchings. Mr. Soderlund, do you have any questions for Mr. King?
Thank you. I do not. Thank you.
Thank you. Ms. Mendel-Rice. If she's with us. or Ms. Mitchell?
I can't tell if you froze or I froze.
Oh,
State
I'm
Water
sorry.
Contractors doesn't have any questions. I'm sorry.
Thank you very much. And Ms. Mitchell?
I do not have questions. Thank you.
All right, thank you. So normally what we do, as you know, Mr. King, is we allow, if you had any, we allow parties to have redirect after cross-examination. Is there anything based on the questions that Mr. Hitchings asked you, very briefly, is there anything that you would like to add to your testimony?
So I'd like to bring back up AHO 69 to the section that he asked me questions about, the seniority.
Great.
That one little.
Do you happen to have a page number, Mr. Hitchings?
That was at page 86, the section we were looking at.
Thank you.
So we go down to the paragraph. So the paragraph he asked referred me to is diversion to sites reservoir for Funks and Stone Crawl Creek. I would just point out that this paragraph is consistent with the testimony of Mr. Walker and Ms. Bazzonia, because it says, and senior downstream water rights on the creeks have been satisfied, referring to Stone Crawl and Funk's Slough. Doesn't mention anything below the creeks, the confluence of Cliffs, but the creeks. I believe it's consistent with my testimony, because this is just limited to the creeks, which is Stone Crawl and Funk's Creek.
Thank you, Mr. King. With that, Mr. Hitchings, do you have any follow-up?
Yeah, just real quick. I mean, the point of the question was to recognize that if there are claimed riparian rights.
No, and thank you, Mr. Hitchings. I understand the point of the question, but do you have any follow-up with?
Yeah, well, I mean, this is kind of the foundation for the question I'm going to note to Mr. King, if it's okay.
Okay.
Really, this was related to the question, like, are you aware that riparian rights are generally senior to appropriative rights, and that any claimed riparian rights that are deemed valid would be riparian to the site's project appropriative right, even with a 1977 date. Do you understand that?
That riparian, are you saying that I understand that a riparian right would be senior to the rights, the 1977 right asserted by the state, which is potentially going to be assigned to Sites Authority, that the riparian right would be senior to that? Is that what your question is?
Correct.
Yes, that's why I'm asserting those rights. But it's, again, I'll state that there was no consideration of those rights in the analysis by Ms. Bazzonia and Ms. Walker.
Do you understand that Ms. Bazzonia and Mr. Walker had reviewed as part of the water availability analysis, they had reviewed the ERIMS database to look for all reported appropriative and riparian rights that would be affected by the project area?
I don't agree with that. I think they've said otherwise, that they actually did not. And then also MBK had mentioned that they actually did not. So I disagree with that.
Okay, that's all I have.
Thank you.
Thank you, Mr. Hitchings. And with that, thank you, Mr. King. Thank you very much for your testimony today. And you are excused from the witness stand, but we will be discussing further the evidentiary objections as we get to that point. I think at this point we have, as I said, we will need to make a break at 11, but I would like to turn to Ms. Moreno, who I understand is our next witness. And Mr. Busher, will you be introducing Ms. Moreno?
Yes.
Thank you. And welcome, Ms. Moreno. It's good to see you. I will go ahead and administer the oath, and then we will proceed from there. If you would, please raise your right hand. Ms. Moreno, do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much. Please go ahead, Mr. Busher.
Thank you, Ms. Kinsey. And just before we start, Ms. Marino's still recovering a little bit. We may need to take a break for just a couple of minutes at some point. And I just want to flag that up front. I've asked her to let us know if that becomes necessary. So if everybody could have some patience for this, we'll try and get through it as quickly as we can. So with that, Ms. Marino, can you please state your name for the record?
Crystal Moreno.
And do you understand that you're providing your testimony under oath this morning?
Yes, I do.
Okay. And what is your current job?
I am program manager of traditional ecological knowledge for the Shingle Springs Band.
Is Exhibit FOR 329 a true and correct copy of your statement of qualifications or biography?
Yes.
And is Exhibit FOR 330 a copy of your written testimony for the rebuttal phase of this proceeding?
Yes, it is.
And did you prepare that document?
Yes.
And are Exhibits FOR 332 through 341 copies of exhibits that you identified and attached to your written testimony?
Yes.
And is Exhibit FOR 331 a copy of a summary presentation of your testimony?
Yes.
And did you prepare that summary?
Yes.
If we could put 331 on the screen, and Ms. Moreno, if you can go ahead and summarize your testimony.
Do I need to read this slide? Yeah, okay, next slide. Traditional ecological knowledge, what is it? So TEC refers to the evolving knowledge acquired by indigenous peoples through direct contact and experience with our environments over millennia. It's recognized by entities like the EPA and U.S. Fish and Wildlife Service as vital for informing environmental governance. A couple key principles. TEK is a system of responsibilities passed down generationally. It includes ecological knowledge as well as cultural and spiritual practices tied to the land. Next slide. TEK's role in environmental decision-making. In policy, there's national and state agencies have increasingly recognized the importance of integrating TEK into environmental policies and decision-making processes. Key policies and frameworks include the EPA's policy on environmental justice for working with federally recognized tribes and indigenous people, specifically urges consideration of TEK in environmental decision-making processes. Also, California State Water Resources Control Board, tribal consultation policy emphasizes meaningful participation of Native American tribes, ensuring our input is considered when developing water regulations, policies, or plans. In 2023, the Water Board engaged with tribes to document TEK and traditional resource management strategies for the San Francisco, Sacramento, San Joaquin Delta estuary. Next slide. Shingle Springs Band connection to the land. So some tribal background. Shingle Springs ancestral lands extends across delta waterways like the Sacramento and Feather Rivers. The tribe has a deep connection with these waterways and dates back thousands of years, despite colonization, forced relocation, and loss of ancestral lands. Cultural preservation. The tribe created a TEK program to reconnect with ancestral resources and knowledge, ensuring cultural practices continue.
I'm sorry, Ms. Moreno, this is the court reporter. I need you to slow down even though you're reading. I'm trying to make a verbatim record.
Sure. The tribe purchased land at the ancestral village site of Woloch in 2017, reaffirming the bond with the Delta. Next slide. Observing environmental change through TEK. Impact of water degradation. Shingle Springs Band members observe the degradation of delta waters, including low water quality, fish die-offs, harmful algal blooms, and contamination. These environmental changes disrupt tribal practices, such as conducting religious ceremonies. Key TEK observations. The tribe understands that the health of river species, like salmon, is linked to the overall environmental health of the Delta. Observations from tribal members support concerns about long-term environmental impacts from water projects like Sites Reservoir. Next slide. Integrating TEK with Western science, combining knowledge systems. The tribe has used Western scientific methods to validate our TEK insights, particularly in areas like water quality testing and environmental health. An example, after noticing algae blooms, water tests confirmed harmful contamination, validating TEK observations. Other examples, in fire management, cultural burning, which is a traditional practice, aligns with controlled burns in Western science to prevent destructive wildfires. Next slide. Excuse me. TEK as evidence of environmental impacts. Natural flow regimes. Through TEK, the Shingle Springs Band has recognized the critical importance of natural river flows for ecosystem balance. Alterations to water flows can disrupt ecosystems and undermine the health of the environment and tribal practices. Impact of Sites Reservoir. The tribe believes that the Sites Reservoir, by altering natural water flows, will exacerbate environmental degradation in the delta, harming plants, animals, and people reliant on the waterways. Next slide, please. Failure of consultation by the Sites Project Authority. Lack of government-to-government consultation. The Sites Authority failed to engage with the Shingle Springs Band as required under AB 52, which mandates early, formal consultation with tribes that may be impacted by projects. The tribe's concerns about water impacts and cultural resources were not adequately addressed in the planning process. The need for respectful and meaningful engagement. Meaningful consultation requires more than a single email or letter. It must be a process that integrates tribal concerns into project design, impacting policy and mitigation measures. Next slide. The importance of TEK in protecting tribal interests. Understanding tribal connection. So the Shingle Springs Band TEK reveals a deep understanding of how environmental changes affect cultural practices, such as the use of plants like tule, which are vital for ceremony and regalia. Unfulfilled consultation and knowledge gaps. The authority's failure to properly consult with the Shingle Springs Band led to the omission of crucial information about the tribe's relationship with land and water. Next slide. The cascade of harm caused by altered flows. Impact on ecological balance. So changes in natural water flows affect plant and animal life throughout the ecosystem, including native fish species like salmon, critical to the tribe's cultural and subsistence practices. TEK's warnings. The tribe's generational knowledge indicates that diverting and storing water will further harm the already struggling delta ecosystem with cascading impacts on downstream tribes. Next slide. Conclusion. A tribe's warning. The proposed Sites Reservoir will harm the Shingle Springs Band's cultural, spiritual, and ecological connections to the Delta. Without early consultation and integration of TEK, downstream tribes' interests will continue to be disregarded. Urgent need for holistic management. To protect the Delta's waterways and the cultural survival of tribes, the authority must engage with tribes in a meaningful and respectful manner, incorporating TEK into the decision-making process. And I think that's it. Oh, until the authority engages in proper consultation and acknowledges the importance of TEK, the Shingle Springs Band recommends that the Sites Reservoir project not proceed.
Thank you, Ms. Moreno, and thank you so much for being here. I can tell you're not feeling your best, so I really appreciate it. I would like to go ahead and take a 5-minute break. I need a 5-minute break. We'll give you a 5-minute break to rest your voice and maybe get a drink of water before we proceed with cross. So let's come back at 10:31.
Thank you.
Thank you. All right, welcome back. I'll look to the court reporter. Are you ready for us to go back on the record?
Yes, I'm ready. Thank you.
Great, thank you. And with that, I will look to Mr. Ferguson. Do you have questions for Ms. Moreno?
I do.
Please, go ahead.
Morning, Ms. Moreno. My name's Aaron Ferguson. I'm with Somax Simmons and Dunn, and we're counsel to the Sites Project Authority. I'm going to ask you some questions about your testimony this morning, okay?
Okay.
I'm going to start on page 5 of your testimony in paragraph 7, where you mentioned that the authority's testimony fails to consider tech despite guidance from the EPA, the State Board, and other environmental regulators about the need to carefully integrate tech in collaboration with tribal knowledge when considering ecological and cultural impacts of water projects on tribes. You see that testimony?
Is that something you can put up on the screen?
Sure, that's a good idea. Let's bring up your testimony.
Thank you.
FOR 330. Yeah, so page 5 at lines 13 through 17. You see that testimony about what you state as the authority's failure to consider tech?
Yes.
The authority is not legally required to consider tech when evaluating the impacts of the site's project, correct?
Objection calls for a legal conclusion as to what they're legally required to do.
Sustained. Will you please rephrase, Mr.
Yeah,
Ferguson?
are you aware of any legal requirement for the authority to consider tech in evaluating the impacts of the site's project?
I am not aware, other than under AB 52, you're required to consult with tribes. TEK would be a part of that consultation.
On page 8, excuse me, paragraph 8 of your testimony, I'm sorry. It is page 8. I'm looking at paragraph 15. One more correction. At the top of page 8, excuse me, lines 1 through 2, you state that the authority never engaged in government-to-government consultation with the tribe as required under AB 52, correct?
Correct.
What is your basis for stating that the authority was required to engage with the tribe under AB 52?
Can you repeat the question?
Yeah, what is your basis for stating that the authority was required to engage in government-to-government consultation with the tribe under AB 52?
Well, it's a project that would impact the tribe's ancestral territory, and a project impacting tribes, I believe, is a requirement under AB 52 for tribes to be consulted with.
And you're aware that AB 52 imposed a tribal consultation requirement as part of the California Environmental Quality Act?
Yes.
Is that correct? Are you aware that the California Court of Appeal has upheld a trial court ruling denying all challenges to the authority's CEQA compliance related to the sites project?
I am not aware.
Okay. At lines 9 through 12 on this same page, so this is in paragraph 15, You discussed what you call formal and informal consultation, correct?
Correct.
Okay. And you state that the Shingle Springs ban fell into the authority's second category of quote unquote informal outreach to tribes. Is that correct?
Yes.
Do you agree that Chairperson Cuellar received an email on July 8th, 2021 from a representative of the Sites Authority requesting her input on the project and the authority's evaluation of tribal cultural resources under CEQA?
I was not aware of that notification. I was told about it.
When were you told about that notification?
I learned of it actually when you were questioning the vice chair. That's when I learned of it.
Okay, so last fall.
Yeah, whenever that was.
Do you agree that Chairperson Cuellar never responded to this email?
I do not agree. I don't know that. I don't even know that she actually received it.
Okay. Do you know if any representative of the Shingle Springs Band ever responded to the email to Chairperson Cuellar?
I do not know.
As, Assuming Chairperson Cuellar received and read the message, do you agree that there was sufficient time for the tribe to respond to the authority's request before the authority ultimately certified the environmental document?
I do not agree.
Do you know the date on which the authority certified the environmental document?
I do not.
If we can bring up sites 95, please. And then turn to page 333. Oh, I'm sorry. Can we go back to page 1? You know what? I'm realizing I've got something wrong here that I need to take a look at. Let me just ask you, you just responded that you don't agree that there was sufficient time for the Shingle Springs Band to reply to the authority's request for information, correct?
Objection misstates the testimony. He asked her if she believed there was sufficient time to engage in consultation, not to reply to an email.
I think that's fair. Would you care to rephrase your question, Mr. Ferguson? Based on that comment?
Sure. Yeah. You just responded that you didn't believe there was sufficient time for the Shingle Springs Band to engage with the authority between the time of the email that was sent to the tribe and the time that the authority certified the EIR, correct?
Correct.
And yet you subsequently acknowledged that you weren't aware of the date on which the authority certified the EIR, correct?
Correct.
So what is your basis for stating there's insufficient time?
Because I have no way to know if the chairperson even ever received your email, the email that, was supposedly sent to her.
Well, I asked you to assume that she did receive it.
Objection argumentative.
Yeah, Mr. Ferguson, I'm not sure where we're going with this line of questioning. I don't think it's particularly helpful.
Okay. Well, she's repeatedly in her testimony stated that consultation was insufficient and not early enough. And so I'm trying to get at her understanding of the amount of time that the tribe had between the time the authority contacted the tribe and the time that the authority certified the EIR, and get her sense of whether that was adequate time for the tribe to engage.
To the
Mr.
extent that's a
Ferguson-
question, I mean, I think it lacks foundation. She said she didn't know when or whether the chair received that email, and she learned about the email last fall.
Which is essentially what I was going to say. I'm not sure if Mr. Ferguson, if your question is how much time Ms. Moreno believes is necessary for appropriate consultation, you could ask that question.
Okay. That's a good question. Do you have an opinion, Ms. Moreno, on how much time you believe is necessary for adequate consultation?
I believe that the tribe should have been notified at the outset of the project. In our opinion, the way that we look at meaningful consultation, you notify tribes early. It's more than one email. You build a relationship with that tribe, and you listen to what we have to say. That's the point of consultation with tribes, is we're supposed to be a part of the process from beginning to end. And we weren't, that didn't happen here. That didn't occur.
And with the site's authority project, what time period are you suggesting was the beginning that you believe that the authority at which time you believe the authority should have contacted the tribe?
Well, in 2017, tribes were contacted that I guess were assumed to be the only tribes in the footprint of the project area. So Shingle Springs at that time was not contacted, is my understanding.
Okay, so assuming the authority did contact Shingle Springs in 2021 when they sent the email to Ms. Quaylar, is it your testimony that the Shingle Springs band was not afforded some sort of opportunity to engage that was at that point in time, because it was not as compared to if it had been contacted in 2017?
Objection vague.
Yeah, is it your testimony that, let me back up. Assuming the Shingle Springs band received the request for input in 2021, is it your testimony that the Shingle Springs band didn't have some opportunity to engage at that point that you believe would have existed if it had been contacted in 2017?
Can you rephrase the question, please? Or repeat it?
You're suggesting that the authority should have contacted the Shingle Springs band in 2017, correct?
Correct.
And my understanding is you believe that's the case because there are certain there's a certain importance in contacting the tribe when a project evaluation first begins. Is that correct?
Correct.
So that suggests to me that you're saying there was a lost opportunity to engage because there was a time span that went by between 2017 and 2021 when the Single Springs Band was not contacted. Is that correct?
That's correct. There was a loss of time and opportunity.
So I'm asking you, what do you believe was the lost opportunity with respect to the Shingle Springs Band ability to engage once it was contacted in 2021?
So you're asking me what was the lost opportunity to engage when we were contacted in 2021? Is that what you're asking me?
Yes, yes. Yeah.
Okay, so from my perspective, project starts planning in 2017. We're now 4 years later, and a notice is sent to Shingle Springs when you already have this plan done. That defeats the purpose of consultation. Your method of notice was inadequate. So there was no notice from the project outset. You state that a notice was sent to the chairwoman in 2021. I don't know that she ever received that, but your process is still lacking. Consultation isn't one email to one person. If you are upholding your obligation under AB 52, you conduct outreach to the tribe, and that's not one letter.
So in that response, you indicated that the project was done at the point the authority contacted the tribe. Is that correct?
The project planning and design, I feel like, was done.
So that was the basis of my questions about when the authority adopted the EIR and certified the EIR, but you say you don't know when that occurred. Is that correct?
That's right.
Okay. If I were to represent to you that the authority didn't certify the EIR until November 2023, which would have been 2.5 years after the authority contacted the tribe, would your opinion about the authorities contacted the tribe still be the same in terms of being too late?
Yes.
So it's your opinion that 2.5 years of time to engage on the scope and potential impacts of the project was inadequate?
Yes.
What's your basis for saying that?
You didn't consult with the tribe. That's my basis.
Assuming Chairperson Cuellar received the email and read it, do you believe that the tribe had some responsibility to respond and reach out themselves to the authority?
If the letter had been received, and if it was a project that we, flagged for impacts to the tribe, then the tribe would respond.
Have you had an opportunity to review any portions of the authority's environmental impact report?
Some of it.
you agree that this environmental review analyzed the impacts that may to resources that are important to the tribe?
Objection, vague over broad.
I'll allow the question.
Can you repeat the question, please?
Yeah, I'm asking if you agree that the environmental review analyzed impacts to resources that are important to the tribe.
Specifically to Shingle Springs?
Yes, the Shingle Springs ban, yes.
I don't know that. I don't have an answer.
My understanding from your testimony is that the tribe is concerned about downstream water quality. Is that correct?
Yes, that's correct.
Did you have an opportunity to review any portions of the EIR concerning potential water quality impacts?
From my recollection, I believe it said something about the historic flows and you all coming to the conclusion that there would be no impacts. It's been a while since I've read it, so.
And is river flow an issue that's important to the tribe?
Yes, absolutely.
And so your understanding is the environmental review evaluated the potential impacts on river flows. Is that correct?
Yes.
And just taking the analysis of impacts on river flows as an example, is it your opinion that if the authority had had an opportunity to directly engage with the tribe, that that analysis would have somehow been different?
I imagine that it might have been. Had you consulted with the tribe and, understood from not just a TEK perspective, also a Western science perspective, and implications for some of the tribe's land going into trust on the Sacramento and Feather River. I think it may have perhaps changed your analysis.
Are you able to offer any more specifics in the way in which you think it would have changed the analysis? And I'm referring to, in particular, to impacts on downstream flows.
Sure. So the Verona land went into trust. So there's some federal reserve water right coming into play here. You've seen in my testimony, my written testimony that was submitted, that the tribe has started a water quality testing program, and we've been testing water there where harmful algal blooms have been detected, high levels of E. coli. And so there were certain cultural activities that had to be canceled altogether, to try to protect the health of the tribal community. So yeah, we're concerned with flow. We are fans of natural flow, and healthy rivers and waterways and fish.
Mr. Ferguson, let me interrupt. We're 4 minutes to 11. Approximately how much longer do you think you have on cross?
Probably 20 to 30 minutes.
So we'll hit pause here. I want to look to you, Mr. Busher and Ms. Moreno. I think we have two choices. One is we break now and then take basically a lunch break and come back at approximately 12:30 and pick up there. The other option is we come back at 11:30 and see if we can get through Ms. Marino's testimony. And then excuse her essentially before we take our lunch break. And I'll look to either of you, whether you have a preference on how we manage that.
I would prefer to just get it done.
Okay, I didn't want to assume,
Yeah.
but that sounds good. And I apologize for the break here. So let's go ahead and we'll call a break. We'll resume at 11:30 and we will go, essentially my intent would be to go as we need to so that you can finish your testimony, Ms. Marino. Of course, if you need to take breaks while we're doing that, please let me know. And then we will, after that, once you're excused, break for lunch. So that would be my intent. Before we take a half-hour break, is there anything else we should address in terms of scheduling? Are we clear? All right, great. I will see all of you at 11:30. Thank you.
Thank you.
All right, welcome back. I will look to our court reporter. Are you ready for us to go back on the record?
Yes, I'm ready. Thank you.
Great, thank you. And I see we have Ms. Moreno, and we have Mr. Busher, and we have Mr. Ferguson. So I will turn things back over to you, Mr. Ferguson.
Okay, thank you. Ms. Moreno, on page 9 of your testimony at lines 5 through 7, and do you want to bring that back up again? We can do that.
Thank you.
It's a FOR 330. Yeah, thank you. Can we turn to page 9, please? At lines 5 through 7, Ms. Marino, you state that the authority also did not meaningfully engage with the tribe in any way in the course of planning the project or analyzing its reasonably foreseeable environmental, cultural, social, and economic impacts, correct?
Correct.
And what is your definition of meaningfully engage in this context?
Well, as I stated earlier, talking with the tribe early, often building the relationship, and really coming with, a genuine intent to hear the tribe's perspective and understand, our sense of the project impacts to us and to our, animal, fish, bird relatives. So yeah, meaningfully engage, is something that should be measured by the tribe.
And is it your testimony that that's important to ensure that the, for example, environmental impacts are adequately evaluated?
Yes.
Okay. And if we can focus on the environmental impacts for a few moments, I think before we took our break, you mentioned that water quality was one of the issues that is important to the tribes. Is that correct?
Yes.
And I think you also mentioned river flows, and I believe you may have mentioned that in the context of talking about the tribe's water right. Is that correct?
I was talking about flows generally, just natural river flows. But then I also mentioned the Verona land now being in trust and the implications there for tribal reserved water rights.
Okay.
And the tribe already has riparian rights there.
Is another resource the tribe is concerned about the fishery in the river?
Yes, absolutely.
Do you agree that the authority's environmental impact report analyzed the project's potential impact on water quality, fish, and river flows?
My understanding is
Go
that,
ahead.
sorry, did I cut you off?
No, go ahead. Go ahead.
Okay. My understanding is that your EIR, and in my opinion, is inadequate when it comes to these things. So I understand your EIR made some evaluations. We just felt like it did not include things like talking with Shingle Springs and understanding impacts to the tribe.
Do you have an opinion as to how the authority's analysis of the project's potential impacts on those resources might have or should have been different if there had been the discussions you're talking about?
I don't know that you would have arrived in a different place. I just know that without talking to us, you don't get our feedback and our input.
Do you have a specific example of any sort of factor that you believe the authority should have considered in the evaluation of the impacts on the three resource categories we just discussed?
Can you restate the resource categories?
Yeah, it was water quality, fish, and river flows.
Okay, and so water, let me write that down. Water quality, fish, and river flows. Okay, now can you ask your question again, please?
Yeah, I'm asking you whether you have an opinion as to whether the authority's analysis did not include a factor related to those items that you believe the authority should have included and perhaps would have learned about through direct discussions with the tribe.
I mean, I think again, it comes down to the tribal impacts. So the poor water quality we're already experiencing, which would be exacerbated by yet another diversion on our river. The fish species that are already in decline. And so from the tribe's perspective, salmon is a relative. Salmon is a being that we are responsible for. Those without voices, we speak for them. It is part of our responsibility as Indigenous people. You did not talk with us about that in any type of way. River flows, the natural flows of river, things that we know are necessary for the survival of species and the totality of the cultural landscape and cultural ecosystems.
So is it correct that the tribe doesn't necessarily have a disagreement with the scope of the analysis that the authority undertook with respect to impacts on these resources? It has more of a disagreement with the results.
I wouldn't say that.
Okay. At the bottom of page 9, in paragraph 18, and then this carries over onto page 10 as well. But you claim that if the authority had engaged in meaningful consultation, it would have learned of the tribe's lands at Verona that already have associated riparian rights, and that once in trust would gain tribal trust rights, both of which are subject to injury by the site's project, correct?
Correct.
The Shingle Springs Band has not submitted any documentary evidence of its claimed riparian or tribal trust rights in this water right proceeding. Is that correct?
It would depend on what proof you're talking about. I mean, we stated it in the testimony, so.
So you've not, the tribe has not provided any other written documentation of the tribe's rights in the context of this proceeding, correct?
Other than what's in my testimony, is that what you're asking?
Yes.
But not to my knowledge.
Okay. Were you aware of a request that the AHO made to the parties in this proceeding in January 2025, asking for documentary evidence of water rights so that it could evaluate potential claims of injury by the project?
I was not aware of that.
Okay. When was the tribe's land placed into trust?
I believe officially in December of 2024, and then there was a subsequent signing ceremony in January of 2025.
So at the end of paragraph 18, if I'm understanding your testimony correctly, you
Sorry, I just need a minute.
sure.
Okay.
Yeah, my understanding of your last sentence in paragraph 18 is that you're criticizing the authority for failing to consult and incorporating information about the tribe's trust rights into the development of the project, correct?
Can you ask that again, please?
Yeah, can
We
scroll
scroll down to see the end of
Yeah.
that? Yeah, thank you.
So the last sentence in this paragraph, which begins with ultimately, you see that sentence?
I do, yes.
Since the land was just placed into trust in December 2024, there really hasn't been an opportunity for the authority to incorporate that information into the development of its project, correct?
Incorrect. Had you engaged with us and consulted with us, you would understand that when a tribe acquires property and starts the trust process, it takes a few years to do that. So you would have known that.
But my understanding of your testimony is that you're suggesting what the authority would have known about is the placement of the of the land into trust, correct? And that would have made a difference in the development of the project.
Yes.
And that didn't occur till December 2024, right?
It officially did not go into trust until December 2024. But like I said, the process takes a few years. So you would have been aware of that process having been started and coming to finalization.
On page 11, we could scroll to that at lines 4 through 9. You state that without AB 52 consultation or meaningful engagement, the authority lacked the generational knowledge held by the tribes regarding delta flows and their relation to delta ecology, correct?
Correct.
Can you provide specific examples of how generational knowledge may have resulted in material changes to the authority's environmental analysis?
Sure, I can give you an example. So as we talk about the Verona land going into trust, and we talk about the tribe's connection there, the village of Wollock. The tribe has, connections, ancestors are there from the beginning of time. That location is pretty important when we're talking about the 4 different Chinook salmon runs. It's unique in that those 2 rivers come together, Sacramento Feather. There's also the Sacramento Slough, which runs into Butte Creek, just a bit further up the Sacramento River. And it's unique because you don't find many places where all 4 runs of salmon come through. The Verona property, the way that it lays geographically, creates 2 seasonal ponds on the south side of the property and then another on the north, which is salmon habitat. And this has been known, through TEK. We know this. We know the importance of river flow. We know the importance of the seasonal flooding in that area that creates, habitat during certain times of the year. But actually, it's habitat year round because the river is the habitat. The river is the primary habitat for all these runs of salmon.
Do you agree that the authority evaluated the project's impacts on fishery resources in its environmental analysis?
I would say yes, but it was limited.
Are you aware that the California Department of Fish and Wildlife has issued an incidental take permit to the authority for operation of the site's reservoir project?
Yes, I'm aware of that.
And are you aware that that incidental take permit was issued based upon analyses of potential impacts to endangered salmonids?
I understand that.
Okay.
I don't agree with them, but I understand that.
Okay. On page 11 as well, if we can scroll down at line 21. You state that the authority's witnesses point to general water quality and flow testimony that does not take into account the particular ways in which the tribes engage with the water, correct?
Correct.
And I'm assuming you're referring to the Sacramento River water. Is that correct?
Sacramento, right, and as well as the Feather, the tribe's property at Verona is at the confluence there.
What sort of methodology or analyses do you assert should have been used to account for the ways in which tribes engage with the water?
AB 52 consultation. I mean, even awareness of tribal beneficial uses through the state water board process and the regional board processes. These are something, this is something that's, been defined since 2017. TBUs aren't anything new, but we would have been able to provide more detailed information had you had the conversations with us.
Are you suggesting that there are factors that, for example, the water quality analysis that the authority performed in the EIR should have considered in order to be attentive to the ways in which tribes engage with the water?
I think my answer is yes, but can you restate it? Can you repeat that?
I'm asking you if you're aware of specific analyses that you believe the water quality analysis in the EIR should have undertaken in order to account for the ways in which tribes engage with the water.
Yeah, I mean, I think to be able to understand the increased exposure rates of indigenous people because of the way we uniquely interact with the waterways and and the plants and animals and fish there that the analysis is lacking because you don't understand these things from the tribal perspective. You don't understand our uses of water, and the various exposure pathways and rates that arguably are higher than, a non-native person.
But that exposure, when you talk about exposure, your concern is with respect to exposure to certain constituents in the water. Is that correct?
Toxins, pollutants, contaminants,
Okay.
poor water quality.
And so are you familiar with the scope of the authority's water quality analysis in the EIR?
Objection asked and answered.
In what ways do you believe that the authority's water quality analysis in the EIR does not address the constituents of concern to the tribes when it comes to evaluating how the tribes engage with the water?
Objection, I think that's asked and answered too from the prior question about the specific analyses that were not performed.
I'm asking about the constituents.
I'll allow the question. You may need to ask
Yeah,
it again, though,
Ms.
please.
Marino, I'm sure. I'm asking you specifically which constituents, sorry, something, I'm asking if you believe that there's an analysis of certain constituents you believe should have been conducted that would have been important when considering the ways in which tribes engage with the water.
Yeah, I feel like I answered this, but let me try it again. When you don't talk with tribes, you don't understand how we uniquely use the waterway. It's about exposure pathways, it's about exposure rates to contaminants, pollutants, harmful algal. I mean, is that what we're talking about? Is that what you're asking me if there was something else that you all should have included? I mean, I think I already answered this.
Yeah, I was just trying to get a better sense of the constituents you believe are important from a water quality perspective when it comes to the ways in which tribes engage with the water.
I would say anything that potentially negatively impacts human health. And even beyond that, the health of our sacred species.
I think you previously mentioned HABs, is that correct? Harmful
That's correct.
algorithms as important?
Yes. Yeah, it's a big concern.
And are you familiar with the authority's analysis of the project's potential impacts on HABs and downstream waters within the EIR?
I just can't recall.
Okay. Are you aware of any that testimony that's been offered in this proceeding regarding the project's potential impacts on HABs and downstream waters?
I have not watched much of the hearings.
I don't have any more questions, Ms. Moreno. Thank you.
Thank you.
Thank you, Mr. Ferguson. It's my understanding that Mr. Soderlund does not have any questions for Ms. Moreno. Ms. Mendel-Rice, do you have any questions?
I do not have any questions. Thank you.
Thank you. And Ms. Mitchell, do you have any questions for Ms. Moreno?
I do not have questions. Thank you.
Thank you. Mr. King, I see you have your hand up.
Yes, I actually have a couple of questions.
Well, wait. Is this friendly cross? Because we're not allowing friendly cross. If you understand the idea that you, an attempt to elicit testimony from a witness in support of your, who is supporting your position.
It relates to the takings permit, and whether or not she has knowledge about about the water monitoring, part of the takings permit as it relates to the Knights Landing outflow gates, which are upstream to their diversions. So maybe it is friendly cross.
I
So
think that will be, so I think the situation here will be up to Mr. Busher if he would like to elicit testimony on that, on his redirect. So, thank you, Mr. King. Mr. Busher, do you have redirect questions for Ms. Moreno?
I do not. I do have redirect questions for Ms. Moreno.
Okay. Then I think with that, Ms. Moreno, thank you so much for your testimony. I hope you feel better soon. Thank you for being here in spite of all of that. I really appreciate it, and I really appreciate your time joining us today. You're excused. Thank you.
Thank you.
And we're at 11:58, so it's a good time to break for lunch. I think I've already indicated the procedural issues that I'd like to address after lunch, that we will get to this admission of exhibits into evidence and oral statement of any objections. My plan would be to reconvene at 1 o'clock, but before we break, are there any other procedural issues we should talk about?
I just had one question. Do you have a sense, Ms. Kenzie or others, of how long we're going to need this afternoon at 1 o'clock? I'm with you. I don't think we need till 5, but
Right. It's going to be a matter of stepping through each of the, and I need to, what I'm going to be doing over the lunch break is organizing us, but we'll be stepping through the admissions of evidence. I'll start with the authority, and we'll work our way through it and hear oral objections. That will take a little bit of time just to make sure, because I do want to identify where we have revised testimony and that kind of thing, revised exhibits, just to make sure our records are clear. So it's a little bit tedious, but I think important. I imagine that will take, I don't know how long, but stepping through all the parties. And then I don't think the procedural questions about next steps, as we're generally calling them, will take that long. So I'm hoping not more than 2 hours and ideally less, but that's my guesstimate. Does that help, Mr. Busher? I don't know if that helps.
sure. No,
best I know.
I appreciate I asked a difficult question, so thank you.
Mr. King.
So could the authorities send me the objections to the exhibits they mentioned earlier in the morning? I didn't catch all the exhibits that they're objecting to, and then that way I can respond this afternoon to it.
Yeah, we'll do that, Mr. King.
Thank you. Thank you very much.
Mr. Ferguson. I appreciate that. Anything else before we break? All right. Thank you, and I will see you at 1 o'clock.